up until that point, he was about okay, yeah, he was about to get shut down. I'll send you the video, but I just want to talk to where it's like, yeah, the case got dismissed because of failure to prosecute. Now, this is a whole lot different than raising federal constitutional issues,
Absolutely
right?
is.
Or straw man theory, So, and again, I'm able to analyze all of this now because now I'm able to issue spot right, to some degree, and I'm able to analyze to some degree. And I'm like, wait, you're trying to help me, and you basically got out because somebody didn't show up.
And then you should say it that way.
Exactly. So yeah, I mean, there's definitely nuance to this. I was talking to somebody prior to this too, where when you go to court, I think there's this belief that court, we have this thing where there's a lady justice holding the pendulum and she's blind, and she really just balance the scales. Like, look, you've been watching too much TV, because if you don't go in there properly articulate your issue, and you're able to analyze and use applicable rules, even in that scenario, doesn't mean you're going to 100% get the remedy you request. But at the very least, you should be able to do that, right? Because at that point now, you can go up the ladder to seek your remedy, properly. But if you can't do that, I don't know how else to tell you. You're going to get your ass whooped every time.
And badly at that.
So yeah, this stuff to me, and again, you can only lead a horse to water. You can't force them to drink. And it's even sad where it's more than likely you're the one that the horse is the one that's thirsty. you need the water.
At the end of the day, that's exactly what it is. It's the horse that's thirsty. And I recently joined a unique rank of people, and I guess I could say honestly and with candor that I did have another successful outcome in another issue. What's going on, Kyle?
Hey, what's going on, Greg? What's up, fella? Oh, it's only down there.
Yeah. Hey, how's it going, man?
Yeah, I had another successful outcome, and I know I promised people I'd step away, but I am here for certain services. But I think Daylay is going to do a good job. I think a lot of the guys will, and I talked to a guy today, and I said, this is what we can do. If the guys want me to discuss things, and they can contact you, really, and we do webinars or things that I just don't feel comfortable doing in this platform, I'm down like a flat tire for it, because we've had a couple of other issues pop up, and one of which I got one of the highest compliments known to man.
Oh, here we go.
Yeah, don't hate the player, hate the dang game. I should put on my theme music. Is it true? Yeah, I mean, I gotta find my squid theme music. But don't hate it. What's up, DB? I had one of the highest compliments known to man, and I'm getting inner group hate. I didn't say it. The lady said it. Now, although she said it after severely traumatizing an individual, but we're gonna keep on coming. I thought that was a heck of a comment, or a heck of a compliment. What's up, DB? A heck of a compliment. Yeah, I was called. You want to tell him, Daylay? Because I can say it, and it may sound one way, but since you heard it, you should.
Nah, I think I know you want to say it, so go ahead.
Of course I do, but I want to hear you say it. I only wish I were there when the judge or judicial, whatever she was, courtroom jester, magistrate, whatever she was, she didn't call it mumbo jumbo. She didn't call it BS. She didn't label it SC. She said to the guy, we're not going to do this Johnny Cochran paperwork stuff. I'm like, Johnny Cochran? She compared my drafting to Johnny Cochran? Johnny Cochran? She resurrected the late, great Johnny Cochran and put me in the same sentence with him, even though she didn't know I even existed. But hey, I take the compliment no matter how it comes. She could have called me something else.
Oh, there is no discrepancy or confusion that you are taking a compliment.
Oh, absolutely.
Yeah. Oh man. But yeah, no, like you said, it was definitely a compliment because it's not like she came in and said you're using some bullshit straw man theory. It was just like, look, I'm not dealing with you, Johnny Cochran, today. You know, this is basically it.
Jonathan Cochran. I should bring up a picture of him, put it on there. I gotta do my next backdrop. Call it the resurrected JC show. I couldn't believe it. I'm like, dang. If, after I got over the accident, I didn't have to get over after I listened to what she said to him. You gotta admit though, it was kind of interesting to have her say that my paperwork was Johnny Cochranish.
Oh, very much so. I mean, because if she said something otherwise, I probably would have been worried. Yeah. I
Hey,
mean, it wasn't. I mean, it wasn't my hearing, but I mean, the knowledge and the application still has to do with mine. So I would have been worried she said something otherwise.
oh man, but hey, I'll take the compliment any way I can get it. And what it should do is hopefully encourage people to not follow me, but just follow the law. Because that's all I try to do is stay within the guidelines of the law, and hopefully that can help people arrive at a positive outcome. So, well, I guess as we wait for people to straggle in, are the ones who may remember, they may think I'm gone. Tell them what you plan on doing moving forward, Daylay, so we can kind of lay it out as to what direction you may want to take this, or how we may move forward with me, taking a step back from the weekly shows, and actually even explain to the people why we've taken this position.
Which position, as far as you stepping back?
Yeah.
Oh, okay. Yeah, I mean, I think that's been quite clear because you said it multiple times. The reality is that this is the truth and reality of it all is that this is not a one man show, one man race, right? Like, you picked it up from somewhere as well, you know. So, and the notion, the point has been for you is always to help people, you know. And one of the funny African sayings, like the most selfish thing you can do for is to help others, right? Because essentially you end up learning more from that process. And that's kind of where I'm stepping in too, because I still got my own case, and issues I still need to resolve. But part and parcel of why I come here to all these classes is because I'm able to learn from other people's mistakes. I'm able to get reps. I'm able to learn things. And in that aspect, I'm picking up kind of where you left off, where I will be kind of sitting that seat now and hopefully be helping people out. Now, I'm not trying to recreate the wheel from that standpoint because obviously you've done like 40 plus shows on this, right? Whereas like I think I might start from like maybe having a weekly meeting where we all could just get online and kind of see if we can, just talk about issues and see if we can help each other, kind of like we're doing Saturdays and whatnot. And then as I get more comfortable with it, probably step more into the, consulting part of things and, helping people out, on a more individual level, you know. So that's kind of my approach to it. And again, before I get comfortable at that point, I want to also resolve my case, get the remedy I'm seeking, because I would hate to be the one trying to say I'm telling you do all these things and I haven't got the same results myself. Kind of like how you could sit on here and someone try to question your credentials. You're like, all right, let's go to the Dropbox. Look at my docket. Look at the output I've got. So for now, I think we'll just probably start out with Saturdays and we can all stumble through our issues ourselves. And again, you stepping back doesn't mean you're necessarily going away. Whereas I could tap in with you and say, hey, what do you think on this? This is what I was thinking. How do you see it from this standpoint? Or if it were you, how would you approach the situation? How would you do this? But it just wouldn't be a thing where you would be at the forefront at this point.
Right. And I think that that's the best way to help people step forward. That, and the other thing is, I think we're not talking enough about it, is guys have to get inside the courtroom. You have to go in there and get your reps in. You just have to. If there was any other way, hey, I'd be all for it. And which is why I want to talk about package boys and what I call it courtroom experience versus rhetoric, whatever the topic is or however it is on the screen. That stuff has gotten, and you know, it's taken a hold. Rhetoric is taking a hold over our entire society, which is crazy. When we have information, I was watching stuff with Carl Sagan earlier, and he said he kind of saw this coming. You know, there's a book called The Dumbing Down of America. There's actually a couple of them that kind of touch on that topic, where people stop critically thinking. I call it package boy paper and internet rhetoric, courtroom performance versus that stuff. And like you said, you watched something just now, and the guy, for the sake of selling something, he misleads the context. Like, and I'm like, what does that benefit the masses of people who may be hanging on something that you did? But like you said, when you can actually see it for what it is, it's like, okay, this is BS. It's like I've told people now lately, I mean, much more lately than I did in the beginning. A lot of that stuff these guys are saying just doesn't work. It doesn't have any place at all in law. It doesn't. And anybody who tells you it does, they don't know it. They don't know it either, because they could just come back and show you, or they could duplicate it for anybody. If it's simply the paperwork alone, I could give you the document, and that would essentially rid your situation. It doesn't work that way, and we've seen a couple of incidents, actually 1, 2, I think 3 this week, right, where guys walked in and it didn't go the way that they expected it, nor did it coincide with the established case law. And in some instances, it had more to do with their ability to volley back the information in a manner that could help them at least set up. And I think a couple of the ones I listened to did a decent job to set themselves up for appeal. And let me say this: I'm not an attorney, so I don't have a license to practice law. I don't practice law. What I've done is study the law and tell people what I learned based upon my experiences and how I got that information. So I don't give information as advice to apply to your specific case, but it's general information regarding the law and lawful principles, which, by the way, do belong to the people. So use all the information obtained from this show for educational edification only. And the reason I say that is because I want nothing that I say to be construed to be given as legal advice. If you feel you need legal advice, I would highly encourage you to hire a licensed and hopefully a competent attorney like the great Johnny Cochran was, and be legally advised. And with that being said, please enjoy the show. But with that, but on the heels of that, I don't think the road to this is ever going to be easy, and I hope that I never made it appear easy. I hope I never gave anybody some false expectation that simply by walking in and doing whatever, that it would be enough to get them some sort of relief. And by the way, if you want to speak, was it hit the button and then press your hand or whatever it is?
Yeah, hit tap the reactions button, and then there should be a raise your hand emoji.
But to what I said, do you think I make this seem easy, or that I make my journey appear that it was easy?
I don't think you portray it as easy. I think the accumulation of your knowledge and application of it seems easy, but that's because you have a depth of knowledge that the average person doesn't have, right? Like, actually, let me ask you this, because I have I heard this before, but I think it was in regards to Navy SEALs or whatever, that the first thing that they do in training is train people on how to handle a gun jam and how to carry a dead body. Is that correct?
Kyle, I was never in the Navy, so I don't know. Kyle, is that correct? Based on your understanding of the Navy SEALs?
I have no idea. I never, those guys, they're their own peoples, man.
For real, their own people.
Right.
Exactly. I wouldn't know, but I know that in basic training in the Army, that wasn't the first thing they taught you. I think the first thing they taught us how to deal with, which is kind of odd, because I don't think they can do it today, is they immediately put stress on you and pressure on you.
Okay. But I mean, the reason I'm saying that is, like, when you see a Navy SEAL shoot, you're just like, man, that looked easy. you know, but you don't understand the complexity that took to display that, you know, that ease. At least for us in software development, right? When you see an app that you say, oh, it's very simplistic, you don't understand the complication behind it, because essentially all those decisions and all those avenues that need to be made have been done in the back end. You just see the click this, click that, right? Now, does it mean that the entirety of the application is easy? No.
Right.
You know, so when I see you in the courtroom, like, okay, damn, that's what I want to do. I mean, now I know, now obviously having conversations with you, I can say, okay, he's been at this 10 plus years, has thousands of hours in it. Now I know I'm not going to do that mental jump in 2 days or in 3 months, you know, and you got your licks. So I don't think you presented as that. I just think that you present yourself as someone who's done the time, and now you're able to, you know, articulate that.
That's cool. Kyle, you had any thoughts, questions, comments?
Yeah. So recently, I just came across some information on my case, and there's a Virginia Code 20 124.3, which states like the judge must file their
One dash 2 what?
20
Okay.
124.3, and it states on the bottom that the judge has to make clear of the decision that they made, the written findings, whether or even orally, um, that of the findings of their decision in a custody case, you know, to both parties. They have to reveal that.
Hold on. I'm gonna pull it up. Hold on.
Uh,
Fair use is always, which is actually in our disclaimer anyway. Okay, hold on. I think I'm looking at the wrong one. Oh, y'all see Google where it says Virginia Code and y'all's Google?
Yeah.
Okay.
Yep.
That
Yeah. Yeah. And if you scroll down to the bottom, after 10.
let's go here. Let's read number 1, and then it'll just say consisting of the following. The court shall consider the following. What does that mean, shall?
Nice.
They must.
So in determining the best interest of a child for purposes of determining custody or visitation arrangements, including any pendent light orders pursuant to 20-103. Is your original order pursuant to this right here? Oh, it says including, so don't worry about it. Including, so let's see what this is. Okay, there you go. Hey, that actually might apply to you, bro. See that?
Yeah, courts may make orders pending suit of divorce and custody.
So that would have answered one of them other questions we had back in the day. Why they could have jumped into the case while you all were still married.
Right.
It was pending. Okay, but the age and physical and mental condition of the child, age and physical and mental conditions of each parent, they shall see. And what this is daily, based upon how you were going through this. What do you see what this does to remind you, maybe even of some other cases we have, to include your own?
The best interest factors.
Yeah, because it says shall consider, right?
Yep. Yep.
It doesn't say it may consider some of, it says shall consider the following, right?
Correct.
And by the way, because this has a set off called a comma, for you guys that didn't pay attention in fucking English class, you can take out that part that's highlighted and go from the top straight to the court shall. You see that? So let's go. So now what I'm seeing, it may be me, but it may appear that this is almost like a checklist, isn't it?
Yes, exactly.
Okay, so keep on going. So we're at a role of each parent has played and will play in the future. The propensity. So what's the standard review for propensity of each parent to actively support a child contact and relationship with the other parent? Somebody else on here should be paying attention to that. The propensity, and see if it applies in your state. These are things they have to do. The relative willingness and demonstrated ability of each parent to maintain a close and continuing relationship with the child, and the ability of each parent to cooperate. I just missed that one. Oh, and resolve disputes regarding matters affecting the child. This is pretty nice. Okay, now the relative willingness and demonstrated ability of each parent to maintain a close and continuing relationship with the child, and the ability of each parent to cooperate in and resolve disputes regarding matters. The reasonable preference of the child. Okay, that might be age. If the court deems the child to be if the court deems the child to be of reasonable intelligence, understanding, age, experience. So that means if it were me, I'd be looking for what is the standard of review for determining these things. Any history of family abuse as in terms any history of family abuse as that term is defined in this section and all these other issues, such other factors as the court deems necessary and proper to the termination. So this 10 would be in conjunction with 1 through 9. Now go ahead and read the next part, Kyle.
All right, the judge shall communicate to the parties the basis of the decision, either orally or in writing. Except in cases of consent orders for custody and visitation, this communication shall set forth the judge's findings regarding the relevant factors set forth in the section. At the request of either party, the court may order that the exchange of a child take place at an appropriate meeting place.
So what is your question?
There's no decision, whether it was written or oral. Um, because it's saying that the judge shall communicate to the parties the basis of the decision. So, yeah, on my court order itself or the custody order, it doesn't state a reason. It just says based off of the evidence the court has found, based off of the evidence and the testimonies given, the court orders and then it pretty much starts going into the custody arrangements, but it never says this is the reason why the court made the decision.
So one more time, what is your question?
Oh, okay. So if it were you, meaning that and being that this was done, the court order was issued in 2022, it's 2025 now. Um, what will you do to seek remedy in this? And then also, if you had a case coming up, a hearing this month for child support, for suspension of license, what would you do?
So if it were me, one, I would see if there's a statute of limitations that would preclude me from even appealing, no matter how far back it is. Did you ever check to see if Virginia has a fundamental errors doctrine?
No, 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 no.
Okay, you might want to. If it were me, I'd see if there's a fundamental errors doctrine. I'd see what their standard of review is for determining if the judge not doing those things is an error of law or simply an abuse of discretion, maybe one and the same. And then I would, if it were me and I had the same situation and I wanted to know, I'd probably just file an action in the court to set it aside for the reasons that would be included between 1 and 10, if it were me. After I would, of course, seek the assistance of an attorney in the beginning, if that makes sense to you.
Right, yeah. It makes sense. It makes sense.
And I would go with it from there.
All right.
Everything else, all right. Any other questions, thoughts, comments? And you said you have you didn't say you had a court date, but you said if I had one this month. The other thing I would definitely do, the order is void based on the court not performing a statutory duty. Yeah, exactly. That would go into error of law or abuse of discretion. But the one thing I would definitely do is make sure I show up. for no matter what goes on. And I would never let a court date come up without me filing appropriate documentation and or without me making sure I had a court reporter present for whatever that may be. I would never, and I mean this for everybody, ever go to any hearing without a court reporter. And apparently the guys are starting to use them a little bit more. You want to make sure that you can provide a record for appeal along the way. Any other questions?
I was probably going to say for the second part that the gentleman raised a question about the license. I'm assuming that's usually the result of probably a mispayment or non-payment. I think one of those things you probably want to look at in that case is the validating the amount and things like that, of that nature to bring up as far as questions. I don't know if there's been a show cause or whatnot, but I just thrown it out there because he didn't give too much details about that.
Right. I see. So I see what you're saying. In other words, if it's an issue of your license is missing a payment, your contention that the license's missed payment is based upon an improper order, you might want to get out in front of it. Otherwise, the order is good until it is deemed not good. Unless you're arguing that the order is absolutely void, which is what came up from our brother in South Carolina. So if you're saying, if your argument is the order is not good at all because the court didn't perform those functions, you got to make sure you find a law that says the court's failure to perform those functions in and of itself would make the order void.
Right. Okay.
Otherwise, it may just be voidable. And again, that's not legal advice. Of course, I would seek an attorney to be legally advised. And if I didn't say it in the beginning, I say nothing disparaging at all about attorneys on the show. So, anybody else have any questions, thoughts, comments? Dale does. Daly does. Daly.
I think I had one just in general. If you could just kind of elaborate on it. For example, in my case, where one of my cases, I have equal custody with the mom, but she's on public assistance. So the state intervenes on her behalf, right? And I remember asking this from the judge because I think one time they said I didn't serve him, and I asked why am I serving them, and they're saying, well, they're providing a service to her, which I'm trying to understand because this is a me versus her case. And if she needs help, what does that got to do from the state? What does that have to do with me?
So what's the question?
So the question is, the state is an intercessor in my case. On what grounds? And I guess as soon as I'm asking it, I'm already realizing how I could go look for the answer myself. But on what grounds does the state has to intervene in the case?
That way, look, that's the issue that you would have to go to your state's constitution, statute, administrative code, whatever it is that they're using to justify the interference. The larger question is, does your state have a specific provision in their constitution that prohibits state interference in a person's private life, like in Article 1, Section 23 of the Florida Constitution? Does your state have a specific provision that may say that they and the state can't do that? And the state is also the agency is the state, for those who don't know. So if it says the Montana Department of Social Services, when they say the Montana Department of Social Services, they're also saying the state of Montana, and whatever it may be for what have you. If that makes sense. So find out what the rules are. And I guess from a general position, if it were Queenie's firstborn, happy birthday, mother. If it was her firstborn, he would make every we would find any and every available defense to keep the state out of there. Because, we all understand what strict scrutiny is. Meaning if the state passes a law, the law has to be least intrusive. Find out what the standard is or the threshold is for keeping the state where the state would have to be in these situations. But I think as a general rule, we know here, I would say that simply because she needs assistance from the state doesn't mean that you have an obligation to help pay for her living or her lifestyle. Those two correlations I've never seen made. I just don't think enough guys ask those questions. And hopefully that did answer your question, Daily, before I go to the hand.
Yep. Thank you.
Indeed. BA.
Shalor.
What's going on?
Hello again. Hey, Daily, I'm gonna try to find an answer for you because I looked at a pretty good presentation out of Minnesota, and there was absolutely the same thing that you're asking. The lady gave an answer to that. It goes to the extent that if a child is receiving government aid, if they're claiming that that's why they have to intervene. It's not verbatim, but it's something along the lines that if a child is going to go on aid from the government and one of the parents opposes it, then they can't intervene. So that might help you. I'll have to dig it up for you.
Appreciate that.
He said that more simply than I did. Yeah. If you object to the state's interference in that relationship. Now, if the child has been granted the aid prior to the state engaging with the presumptive father, you may have a different set of questions there, a different set of issues. But in any sense, it can be addressed. The only way I would think that it could not be addressed is if you do not show up to challenge the issue. I was having a discussion earlier today with somebody, and I'm like, the notion that she had a baby being enough to garner that you owe her money is just nonsensical.
Right.
Legally nonsensical, because they haven't meritoriously determined that you didn't do something that you had an obligation to do. And if the child is the issue, then the child should be what we raise the question for, not some person's lifestyle or daily living.
Right. I mean, gave some more clarification on my issue because I think they're just trying to muddy the waters in my case, because when we originally went to court,
speculation, but go ahead.
Yeah. When we went to court, the mom and I agreed on equal custody. But I had been giving her a sum of amount of money prior to our court litigation. So when we made the agreement in court, they just tacked on, okay, well, why don't you just help her out? They were added support of the same amount. Well, I had bad advice from my attorney at that point. I don't know if you want to go ahead and say your disclaimer. Say your disclaimer.
The views and opinions of the guests don't necessarily represent those of GD9 Attorney Pro Se Consultant, Greg Doss, the alter ego of Shagred Doss, or any of his affiliates. Continue. I see.
Right.
Greg.
I told you earlier that he does have disparaging things to say.
I mean, I do. That's why I always pause for his disclaimer. So, but anyways, the attorney was like, "Oh, it's not a big deal. In X amount of years or so, it'll fall off." Well, I didn't realize the entirety of what I just signed at that time. So when I went through steps of trying to say, "Hey, look, I don't need the services of child support," then they were trying to say that, well, are you not trying to keep your financial obligation to your child? And I'm like, what do you mean? Like, I'm taking care of my financial obligation. She clearly can't because she's requesting help even from the state. So then now it really did perk my interest in, well, why is the state now coming after me for child support? And their thing is like, well, basically you agreed to it at the initiation of the process.
And you're arguing that the state's involvement is impermissibly intrusive, correct?
Correct. Because now my thought process is like, well, look, if I decide of my own goodwill to help her out, that is of my own consent, and I can revoke that at any time. The state stand is like, well, hell no, you can't. And then now it's like, well, who are you? Because I didn't agree. I wasn't talking to you at that time. You know, so who are you now to come and say, okay, now you can't because apparently my child is going to suffer? Well, technically he's going to suffer when he's with his mom. And if you feel that way, well, why can't I have more time then so she could get herself together?
Well, hold on. The question, well, I won't say what you should have done. Had that been me, I never would have asked why can't I. I would have made the statement: the child would be, based upon this set of facts, the child would be better off living with me until the mother gets herself.
Correct.
And
well, I mean,
I've learned from my experiences. When you ask them a question, you open the door. You make
I'm just, this is me and my thought process, because I haven't actually gone, the hearing I was trying to hear, they dismissed it with prejudice. So I'm in the process of having that reverse so I can have my day in court to actually properly articulate these matters. Because I was going off the information of package boys before, and you can see where that ended me. If you want to say your disclaimer, package boy, go ahead. I'll pause.
I will not say anything about anyone specifically when they're not here to defend themselves, but as a general statement, it would work. So just don't mention them by name when they're not here to defend themselves. But they're always welcome to come.
100%, 100%. But that's it for my question. So
okay. Oh. I was going to talk about, I forgot actually, and the people who I was going to speak to it about aren't here. But let me go to my man. Long time no here. He had his case dismissed, and the technicality benefited him. You got to hit the button. What's going on, Rick?
Hey, what up, though?
That's good, man. Long time no here. You feeling better, man?
Hey, I was listening to Daylight. Shouldn't he be raising the fact that, you know, because when the state get involved like that, it's my understanding that the mother is initially surrogating her rights to the state. So what shouldn't he be asking the question, what rights does she have to surrogate like that?
Subrogate, yeah. The same thing I asked, I asked the question to an attorney in that smaller case years ago, and she made the statement, you know, the mother applied for benefits and the state gave the mother subrogated her rights. Some spiel. And my question was just that: does the mother applying for benefits give her a subrogatable right? And then the hearing officer said, "Don't answer that question." And then he and I me and Coffee got into a real good discussion. Now you're the attorney, jackass. But you know, that's not what we're doing here. But it was that set me off to the road that took us to where I am now. But yeah, the mother applying for benefits even if it gave the state a subrogatable right, it does not remove your right to fundamental due process. So what is their issue? What's the state's issue with you? That is the state's issue that the child needs support, and support probably isn't clearly defined in any state constitution to mean solely money, or is the issue that I'll make sure I calibrate, that the mother may need a better job, needs to get her stuff together. What's the issue? But either way, that would be something that, if it were me, I would want to argue has been meritoriously determined. And that's where I think a lot of guys could go a lot farther with this stuff if you focus on what is the issue, or what set of issues. But Daly is definitely on point with his assessment. I just think it's just a matter. We need to probably ask fewer questions and make more statements.
Correct. Yeah, and like I said, I was going this on my own and with the package boys before, which is why I wasn't clear on how to identify the issues that need to be addressed. You know, because they were just like, oh yeah, we're here because we're providing a service. And now I'm like, well, who asked you, nigga? Sorry. You know, like I'm like, I didn't ask for the service. Wow. You know, so all these questions are now popping on my head going through this, you know, our process is like, okay, wait, I need to ask better questions to understand the issue so I can make better statements, you know, so.
I don't disagree. BA.
I was just gonna second some of the last couple of statements there, because I think Daley's and my case have similarities in the same thing. The whole claim of, well, even though my child's mother is not asking the state for benefits, it's the whole thing of, well, something about rights, which I don't quite understand fully yet, is that she surrendered her rights to the state to come file against me now. So I got to figure out how to defend that. And I agree with you in the fact that I have been guilty of the same thing of not asking proper not making statements instead of asking questions to open doors, if that makes sense.
Right. Yeah.
But that's one of the things I have to understand. It's understanding what is it that they mean when they say, well, mom came and, asked for you to come get put on child support, even though she doesn't get, in my situation, she doesn't get, I don't think she'd even qualify for any government aid because of the amount of money she makes. But as one of the judges told me, is the child's right to collect that money. And I already know how some people feel about that, including myself.
I think there's a question about this issue of this right to trial by jury. I think people need to step back and understand that the state has the right to determine its own way of dealing with domestic relations cases, because the United States Constitution did not expressly withhold from the states that specific right. Now, if your argument is that the trial set of issues is a violation of some constitution, some federal right, you may have something there. But I don't know how we keep getting to this thing about the state you have a right to trial by jury and everything, because some of the issues are not judiciable in that sense. I just saw a hand. I thought, am I missing a hand? Yeah. Derek B, you had a question or comment?
Yeah, I just put my little girl to sleep. So look, I'm listening to you guys, and I've been along this thinking the past few days, right, and trying to find some case law that help guide me to what my issue is, right, and my issue is the grant of benefits, right.
Mm-hmm.
When she went down there and filled out the application, and y'all granted her benefits, right? Voluntary approved her application, right? Because they from my understanding in SC, right, it's discretion, right? You could be granted or you can,
they can grant it or they can deny it, and that's up to the state. Yeah.
Right. So with you guys voluntarily granting those benefits and continue to, like, specifically Medicaid, right? Like, as a father, for me, I have the constitutional right of freedom of expression, right? And a part of that expression is being a father and fulfilling my responsibilities. Now, health insurance is a part of that responsibility, and for me, y'all interfered with that.
So, what argument are you raising?
And that's what I'm. You know what I mean? I'm. It's been in my head for the past couple of days, and I haven't.
Oh, you're saying that you have formulated a theory.
Yes.
Well, so let's see. Let's try to couch our theory into a question, because I kind of have an idea what people are saying is the state is what I'm gathering from most people is they believe the state is impermissibly intruded into the private right of family right, which the state can't do without satisfying a standard.
Exactly.
So that's been addressed. What's probably not being addressed from what I'm hearing is more people aren't going in and making that specific argument. Because we can talk about it here all day. It's like Rick boxes, right? So at some point, he can't help you. He can help you. He can show you how to shadow box forever. But at some point, you got to get your ass in that ring.
No question. No.
So what I would suggest to everybody, not so you get your head tore off, but for the sake of getting clarity, so a lot of these questions will go away. At some point, go get in the ring and ask and throw that particular figurative punch. I don't know of any, I have no positive courtroom outcomes that occurred while my ass was sitting in the chair like this. So when you're looking at Dropbox, you'll see a whole lot of court, even when they dismissed the case without me having to say too much. I was still in the venue. And I filed, it was actually a driving out license case that was dismissed without me having to go in there and drag them around the room again, because I'd already done it so many times. They just dismissed the case, but I had to be there. Well, I didn't say I had to be there. I was there because, one, I don't trust them to do shit, right? But I don't know of any way to win without going in. Hey, you can't score a touchdown that counts unless you're in the game. You can't get a layup unless you're in the game. And you have to be willing to get into the game. And what we're learning more and more, at least Dele is a part of the construct of GD NAPSC to some degree now. We're hearing what happens when guys go into the courtroom and they're getting faced with the punch bag. Like, everybody's good with you go hit the heavy bag ain't got no arms. You hit the speed bag ain't got no arms. Or you can run routes against air. Hey, air ain't gonna tackle you. But when somebody's standing in front of you and they leverage inside or they leverage outside of their jamming you, can you get off the jam, or are you gonna let them ride you into the left tackle or right tackle? It's the same thing when it comes to this courtroom stuff. You have got to get into the game to get your reps. So when we talk about all the things that they're doing, okay, you're right. They're doing all that. Now what? Because now we've gotten to what? The now what phase for a lot of the guys. By the way, what's up, TJ? Long time no here. We're in the now what phase. How many guys, by show of hands, if you want to, have actually been in a courtroom now since you come in contact with me? How many of you guys have actually been in a courtroom?
I have.
I know Rick has. Chris has. I think BA has. We know the other TJ definitely has. Hell, I've been in the courtroom since I met you guys. Of course, it wasn't for child support, it's for the shenanigans of Austin Road Basketball Professional Association, who are attorneys in the state of Florida and in fact in Tampa, located on Kennedy Boulevard, for their unscrupulous actions in violation of 18 U.S.C. 208, in concert with Dr. John H. Shim of Shim Spine, who also worked as a treating physician at the VA. We know about that. So, and I can say that freely, and that's my own comment. And if they don't like it, they can sue me if they think I've slandered them in any way, shape, fashion, or form. Other than that, they can kiss my ass. But that being said, when it comes to some of these issues, I don't know of any other way to win other than going inside of the proceeding. I do not know. If there is one, somebody show me. And then, and here's something else I want to say, based upon I think what you said earlier. When I don't know if we were on the phone at the time or not, Dele. I mean, on the presentation. People may grab a specific situation and talk about it as if it means a whole lot to everything, but you don't see them repeat the function. They'll say, hey, I did this in my case, but when you scrutinize the case, you say, well, wait a minute, this is the reason why it happened, not for all the other things that may be social media based popular. Like, okay, they brought this action back here. This wasn't proper. The court dismissed it. Okay, the court just provided its function. But that doesn't mean that child support is unconstitutional. It doesn't mean child support is fraud. It doesn't mean they violated your right to fundamental due process. Simply, or your right to due process was violated. And you say, okay, specifically how? Well, they dismissed the case. Okay, what does that have to do with any goddamn specifically? And I tell guys, when you get ready to go into that courtroom, when you make your, whether you're making your statement in support or a statement or argument in defense thereof, their action, you may want to ensure that you can articulate with specificity why you're seeking whatever it is you're seeking, whether it is in addressing one comment or addressing the totality of a situation. And then we could possibly clean you up on the back end if needed. Or I'm sure an attorney can clean you up on the back end if needed. Any other thoughts, comments? Tell them how to do that thing again, Dele.
You tap on the screen, hit the reaction button. Sometimes it might show more, like with the 3 dots, and then hit the hands raised emoji if you want to speak, and then Greg should.
Or if you just want to ask a question inside the chat room, which I'm starting to learn how to use a little bit, you guys can hit the chat room and we can answer the questions for those who may be otherwise shy. Like Kajaguku, too shy. That's before some of y'all's time though. That's a DJ coming out of me. But some of this stuff is so detrimental, guys, when it comes, because you also don't want to get yourself and put yourself behind an 8 ball by not maximizing on an appearance, because you could go in there and just basically waive a protection. And I would, again, I always suggest that people take the time to look for a competent attorney in your state, see if you can get a consultation. Even if you can get a consultation from one of those, if you're a veteran, you could possibly get a consultation from what's some places called? I can't think of it. Here it's called, I think, Bay Area Legal does some things for veterans and what have you. And you can probably do pretty well with that with some information. At least they can probably hopefully guide you. Or go to your law library, is depending on where you are. I learned a lot, and a shout out to Mr. William and the ladies at the law library in Tampa, because they brought me a long way. Shout out to Miss Benell for explaining to me what a moratorium was. That brought me a long way. Shout out to the gentleman Sundial Shuel Bay for telling me you don't have to pay taxes, and he can show me. Although that wasn't my issue, and he didn't have a history of success, that sparked the interest. Shout out to somebody telling me that you'll never become successful until your assignment becomes your passion. Shout out to Coach Hub for when I thought I was going to quit high school football, which is something y'all probably didn't hear, against Sarasota Riverview. And I know, Mike, you out there, I was getting ready to quit because I wasn't getting any reps. And at the time I wasn't getting any reps, I was like a senior. I'd already joined the Army. And in retrospect, I'll say I didn't work as hard as I should have as a senior after joining the Army in my coming out my junior year. But he put me in the game, and I ended up winning the Player of the Week against Sarasota Riverview. And I kept playing through that. And that's the same coach that when I played, even after that, I could always call on Coach Hub. And he doesn't realize that the trajectory of my life, I believe, is right there in the not giving up anything. And I know I talk to people a lot about sports because sports is the easiest connection for me to make. My academic background, yeah, that stuff, it helps. I won't lie about that or minimize that. Having a father, and I see you, Richard, having a father who was military helped. Having a mother who was in the military helped. Having a brother who's a professor helped. Having a brother, I see you, Rich, having a brother who they tried to claim was what do you call it, Dele? Because he had a speech impediment. My parents didn't accept that. He overcame the speech impediment. Now he's a doctor, a very much tenured professor at North Carolina A&T. These things all help build me. Going to the military myself helped. Coming out of the military, working in education in the school system helped. Going to college helped. Becoming a union steward for the Teamsters helped a lot because it got me ready for adversarial relationships. So there's background to it. So I want to make sure I don't put it out there and make it seem like it's, I definitely don't want anybody to believe it's easy. I won't say it is overly hard because it could be condescending, but I will not leave this part of the conversation without saying I had a lot of damn sleepless nights, especially when I was looking at jail time for those driving out license cases. Every one of those cases that y'all see me in or on here or on the audios, I was looking at jail time. In fact, Rick is listening to him. He'll tell you one of them they were offering like 90 days in jail. I laughed at the lady, but that was for real. Rich, what's going on? You have a question? Uh-oh.
What's going on? How y'all doing?
Hey, you know, I hate the world, but other than that, I'm all right. What's going on? I'm definitely not feeling good. If you want to be honest, I don't understand the Anthony Davis trade. But go ahead, man.
So I'm over here in Georgia in 11th Circuit, and
okay,
I'm in a unique. I've been watching you chiming in every now and then. I'm in a unique situation. So why I say that is, of course, I brought up my issues in the state court. Two issues. One issue was one of the child support agents. They actually fraudulent one of my jurisdictional documents and thought I wasn't gonna catch on to it. So they kind of like started the case. And the other agent, she did some other stuff with paperwork, and I filed a lawsuit on both of them in the state case. Due process, 14th Amendment. And what happened was the Attorney General removed the case and moved it to the 11th Circuit Court down here in Noonan, Georgia. So that's where I'm at now. And what kind of helped me out a lot, why I know the judge is engaging with my case.
So Georgia, you mean the Georgia 11th Circuit Court of Appeals?
Well, I'm sorry, the federal court in the 11th Circuit. I'm sorry,
okay, so
in the 11th Circuit.
You're the same place I am. You've already filed in the federal court. In the federal court, something happened in the federal court, and now you're at the Court of Appeals.
Okay, so that's what the unique part is. So I was in the state court, but because of the constitutional issues that I brought up, the Attorney General removed the case to the federal court. So I didn't even file. He removed it to the federal court.
Only a defendant can remove a case. That's not legal, but only a defendant can remove a case.
Okay. So that's what, and it's so crazy because now he's trying to do all the classic dismissals, like the Rooker-Feldman, the immunity, what's the other one? The
younger Pullman abstention.
Yeah.
Okay, so let's start this. I get this now, but let's not conflate because there's guys listening. You know what the abstention doctrine is, right?
Correct. I can't challenge, a plaintiff cannot challenge an ongoing state of proceedings. I think the Rooker-Feldman is overturning a judgment in the state, or I might have them backwards.
Federal court, backwards. Federal courts typically abstain from state issues.
Correct.
And until all of your state, and I don't know without looking at it, and of course I would definitely suggest you have an attorney look at it, but just based on what I'm hearing, your case was ongoing and still ongoing. So there's no final resolution in the state court. Am I correct?
So that's what I'm getting to. So what happened was, regardless of that, in the law, I actually got it in one of my filings. Once the defendants removed the case, they waive all of that. They waive all the. You can't say the federal can't rule over now because he could have stayed in the state case. From what I've been studying is, if me as the plaintiff, if I removed it and went to the federal case, the federal courts, now you can dismiss it.
You can't remove it.
Well, let me put it like this. Since I filed a notice of
let's ask this question. What is the legal issue at this point?
Oh, my legal issue right now is due process 14th Amendment.
Okay.
Because
what 14th Amendment protection was violated?
Okay, so in Georgia, in the Georgia child support rules, we have to sign a Georgia consent form to participate in Title 4D, right? So that's the issue
Both parties or just any party?
with the non-custodial. So of course, the first party, she fill out the application, more likely it's the she. They fill out the application, so that's their opt-in.
Hold on.
But once they
Hold on. So I was sure trying to get off the hook, but we'll talk on. Is Georgia child support consent form?
yeah, Georgia child support consent form. It's gonna be in the child support rules, and it's actually now administrative, Georgia administrative rules as well. No, not the. Let me see, can I get it? I can send you the link to it. Let me see, I got it right here.
Oh, we've been here before in somebody's case, I guess, because it was highlighted.
Yeah, so it's not that form. That's the form dealing with as if you already participate in the Title 4D. So when you are,
well, I guess where I'm having where I'm a little bit confused is what is so your case. I'm trying to figure out how did you get to the 11th Circuit? I can understand this is what I would see. The 11th Circuit is a circuit court of appeals. Like if you were saying the Georgia Northern or the Georgia Southern District Court, okay, that would make sense. But once they remove the case to the federal court, in order for the appellate court to come in, unless there's some sort of interlocutory issue that you're going to argue while the case is ongoing, your case in the federal court is still ongoing. Once they remove the state, from the state to the federal court, so now the federal court case is ongoing. Did you know what?
Correct.
I can make this even easier. Hold on a second.
I just put the exhibits in the chat. The one I wait to. I just put the exhibits in the chat.
I'm gonna do this right here.
Okay, yeah, go put the case. I'm gonna put the case number in now. 332.
Whoa.
I just copy and paste it in the chat.
What are y'all seeing? Y'all see the Pacer?
Yep.
Okay.
Correct. Yes.
Last name?
Rowe.
First name?
I just put the case number in the chat.
You Richard Rowe?
Yeah.
Well, it's the only one billable page.
I have no idea, but that's exactly what I use the pacer. So of course I can't file a pacer, but I can keep up with the court, the docket. But I just put the exact case number in the chat. Let me see.
Why can't you file and pay? You didn't just ask for permission.
I didn't know that. I've been driving down to the courthouse. I didn't know I could file online.
Yeah, it asked for permission. They let me file. So let me see what's going on. Why I can't find you? That's your Roe Richard, right?
Yeah, it's probably. Let me see. I got to put the third on there. Put the third on there. Put C as a middle initial.
Yeah, but let me see this right here. Hold on. Let me try this right here. There we go. And what year is your case out of?
It just got moved in December. So
is this you? No, that's
no.
You're out of
Georgia, out of yeah, it'd be 11th Circuit, Noonan, Georgia.
What's the date of the case?
No, I'm saying I can give you the exact case number in the chat. The 324 CV00235.
You're still in the federal middle. You're in the federal court, not the 11th Circuit.
Well, I thought my understanding. I thought it was the federal court is in the 11th. This federal court is in the 11th Circuit. Oh no, I'm sorry. The U.S. District Court. You're right. I'm sorry. You're right. I'm thinking about
that. Okay,
something else.
Now it makes a little bit more sense because the 11th Circuit is just the Court of Appeals.
Court of Appeal, correct? Yeah, my fault.
Okay.
I'm speaking.
All right, no problem. Okay, we're good now. I was just making sure because it wasn't added up. Make sure we're still in here, waiting for a ruling. See, that's me. I'm still waiting for these people to rule.
And That's the appeal course you're speaking of, right?
Right. You see this right here?
Okay, yeah.
Yeah, you see my name right there at the very bottom?
Yeah. Uh-huh.
In my you see, and I know this thing moves like molasses, but yeah, I filed directly into the court.
See, that's what I didn't. Well, I didn't know that. I just registered it, and I just keep up with the document without having to file. So I might have to drive down there.
Yeah, you can always.
But
you're actually in the Georgia Middle District somewhere. Noonan is Noonan north or south?
South. It'll be it says U.S. District, Northern District of Georgia.
Which is what I said in the beginning. Okay, there we go. Now we're making more sense out of this. So let's try this right here.
Yeah. 323. Well, yeah, he put his name ROWE, RROWE.
Huh?
The last name is Rowe.
Okay.
And it's going to be plaintiff, of course. All the other ones are my federal case.
Okay. So you filed something last month, about a week ago.
Yeah, just Friday, because I had to respond to his response of my motion for judicial notice.
Which actually I have as a disclaimer. Okay, so here we are.
All right, so like that first filing is when they removed it from the state court.
Right. Oh, you had a lot of exhibits. Okay, so let me see what the actual filing was that was removed. Okay, it looks right.
And that's the lady who did the fraudulent document, the Oprah Lowe. She the one that did all the yeah. So he called himself, when I say he, I'm talking about the attorney, removing it, the one at the bottom of Ficaroto, whatever his name. He removing it to the federal court and try to get a quick dismissal. But what he's doing is not, it don't work because you already invoked federal jurisdiction.
Okay, but wait a minute. Hold on. You're saying you're saying something, okay, but let me go back to something else real quick. So motion to certify class. Did you file this?
Yeah, that's what I'm going to say. That's why I'm at the class certification stage now, and the judge is actually entertaining it.
Did he say that, or he hasn't dismissed it yet?
Well, no. So what it is when I filed my motion, he ordered them to respond, and so you go see that order. That's when he ordered.
That's procedural, though.
So that's what I'm saying. He hasn't dismissed it yet. That's what he hasn't dismissed the whole case yet, because what the opposing counsel is trying to do is do the dismissal, but he can't do that because he already invoked federal jurisdiction. So the judge, he granted the stay because I responded in the same motion. I didn't know that. I thought you could do it all in one. You wanted separate documents, so that was procedure. And which one it was? The clerks. Which one of these you looking at? Well, where I'm in now, that's the order of the judge. He asking them to speak to the rook official, like I just said, and the youngster extension. And the judge knows that you can't do that now. So explain this. You're giving them a chance, right? And that judicial notice that I'm asking the judge to notice is a default judgment from another case in the state case. They defaulted on. They didn't answer me on time. Of course, I know how that go. They didn't answer on time.
They got permission to not get thrown out, and the judge let them just extended the time, right? Because it wasn't
correct. Extended the time, trying to get them time to file correctly, but they still haven't filed correctly.
They can do that. So, did you file a motion for a judgment on the pleading?
Correct. Yep, that's what I'm at now in the state. Motion for judgment on the pleading.
No,
well, no,
federal, not state, federal.
Okay, so the federal. Well, let me back up. The state case is what they defaulted. The other state case I had. So I took that default and I said, Your Honor, can you please recognize this in the federal case? Because they all child support services in Georgia.
Right.
So now he's entertaining that, say, okay, I'm ordering the other side to respond to this, and they still trying to claim Rooker-Feldman, but they can't. They're still doing procedural stuff. They can't do it. So when I come back, I get the last word. I hit him. He's still trying to do that's his response right there. He's still trying to do the Rooker-Feldman and all that type of stuff. You can't even do that now because you already invoked it, federal jurisdiction, right?
Hold on.
Go ahead.
Okay. May take use no on its own or must take. Should not take judicial notice as requested. First, as the Court of Language Rule 201 allows for judicial notice, and the court supply with necessary information for plaintiff's motion. Ask the court to take judicial notice of proceedings, not facts. Okay, you know the difference between this right here, right?
Correct. Yeah, he just using that legal jargon.
Okay, but
in Rule 201, it's everything. You can't separate. Once it is what it is. You can't have like one or the other. Either or. I mean, it's all of it. So my point is why I wanted to come in and speak because
have you done this?
Yeah, I responded already. We can pull up my response. I responded to all that. So
did you do this? Did you provide the establishing the defaults?
So I'm glad you pointed it out. So he's trying to point that out, but it's public record. So you don't have to file the physical copies of public record, just like we don't file every cited case we talk about in the case. So I hit him with that. And the default judgment in Muskogee County, they filed a last minute, so I had to withdraw that one, a partial withdrawal on that one. But the default judgment in Fayette County is still in default. So I pointed that out in my motion saying, Your Honor, it's all public record. You can go in there and look and see for yourself, just like any cited case. You pull it up. It's all public record. It's not nothing like internal. So I already killed his response in my last word. But when I responded with my last word, I hit him with the class action, all the evidence.
Well, how are you going to file class action? You mean similarly situated individuals?
So watch this. In my exhibit, so in the backdrop, I guess I tell you, in the backdrop, I'm doing open records requests in Georgia. I said, give me all the cases y'all that processed in 2021 and 2024. It came out to 1.2 million, right? So I said, okay, now give me all the administrative hearings or administrative orders y'all had in the past 3 years. 1,200. Okay. So just statistically, that's a class of individuals who have been violated due process, 14th Amendment.
When you say class certification, now in the Middle District, you have to be an attorney to file for class certification. If you're saying similarly situated people, that may be different. But if you're saying you just want everybody within this class of people for the purpose of showing that the state has done some demonstratively improper act, is that what you're talking about when you're saying the class? Or you're trying to file a lawsuit for everybody in the class?
So what I thought, I've been studying this stuff for so long, you got to meet 4 different things. And the adequacy is where you request for an attorney. You can have numerosity, typicality, commonality. Okay, I hit all of them.
Hold on. So you're saying where you can request for the court to appoint you the attorney, correct?
Correct. There you go. Okay, that's how you meet that.
No. I get that part. But then the attorney would take the case. So that's where, just want to make sure it's clear for everybody else because it's not a 2-person conversation.
Okay, yeah, exactly right. My fault. All right.
Okay, there we go. So now that makes sense. And if the court certifies that there's a class issue, the court can then appoint an attorney for the purpose of proceeding on the behalf of the class. Yeah.
Correct. Correct.
Yeah.
And because it's a public filing, I'd have had about 3 or 4 lawyers call me about this because of course it's public record. And they're like, man, obviously it's got some merit, I don't know, because the judge hasn't dismissed it. But he also had to wait for the other side to respond. They haven't responded yet. But
it's definitely just to the extent that they chose to remove it and then they couldn't fight their own removal. That doesn't even
that's exactly what happened. And it was like, man, this is real.
I can't say they won't, but let me see. there's a notice because I haven't read the whole case and I don't even see the complaint. I guess you amended your complaint.
Yeah, I had to amend it to make it out more federal court friendly because of course I was in the state court. So I had to amend it and this all federal.
Right. And they're much more scrutinizing than the state court.
Man, what they this federal court, they don't play, boy. They don't play at all. I can see that already.
Yeah.
But that reply number, I think it's number 17.
They didn't file a motion to dismiss this anywhere. Am I missing that?
So that's it right there, motion for judgment on the pleadings. That's when he tried to come in with the Rooker-Feldman immunity and all that type of stuff. But I'd have killed that. And what helped me was the default judgment in Fayette County, because default judgment, all well pleaded allegations are deemed true, right? And I had everything
based on the four corners. Yeah, whatever is construed to be true. Yeah.
So that's I used that against them in the federal case, and what he hasn't granted it yet. But that's why I'm trying to get him to recognize that. Look. Oh yeah, that's another thing. He tried to start off with Georgia tort claims. I'm like, I'm not talking about no Georgia tort. He just switched up so many times, but that's why I think I might got something going here.
What did you ask them for? Some sort of injunctive relief. You didn't ask for money, right?
Oh yeah, in my original complaint, I almost definitely put compensation, emotional distress, all that stuff, so I can always come back to it if we keep on moving on down the line. Yeah, I'm most definitely put it in my original complaint.
Well, you're probably it's gonna be hard to get damage unless you can show some actual damages.
Now, oh yeah, I got that in the state court. I got probably about 50 pages of affidavits, all type of stuff. But I ain't got that far yet in this. But this is the one that he was trying to dismiss it on.
But the judge hasn't spoken to these, but he said he wants to know how these apply. Correct.
Correct.
So it seems like he's narrowed it down to number 3, but he wants them to address why number 3 is applicable, but he never asked them to address why 1, 2, and 4 are applicable to their motion to dismiss.
Because so this is what I'm thinking. This is just me thinking and brainstorming with some of the people I got down to help him out. He already made his mind up. Like this, they can't fight with that. They can't fight with this. They can't fight with that. And he's like, do you actually know that you did move this to federal court? So these two don't even apply either. So I'm gonna give you a chance to kind of correct yourself.
This is standard right here, so I wouldn't worry about that. Well,
exactly, yeah, that's the standard that I've been reading. That's the standard.
Except the qualified immunity issue, that them performing an action within the course and scope of their authority is protected by qualified immunity unless they did it without jurisdiction, which I'm guessing your argument is they did something fraudulently, and because they did something fraudulently, they would have been divested of.
Yep, there you go. Outside they color of law, whatever that is. Yeah. But if you go to the notice at the top, I'm going to show you something that really killed them from the beginning.
Here.
No, the notice of removal. The number 1.
Oh, we thought we did this at the beginning. Okay.
And you go to, I think it's paragraph 3. And I was like, man, he already admitted. So how are you gonna fight it now? You already admitted this. Paragraph 3, the action is a civil rights case and presents a federal question over which the court has original subject matter jurisdiction. So how are you gonna say that in your notice of removal? And now you're trying to say,
wait a minute. Yeah. This is why. That's where his argument is. Not that it's correct, but I'm just saying how, but that's what he just said. Because I was thinking you're saying he waived a defense. Did you see that?
Oh, okay, I see what you're saying, yeah. Without waiving any defense. Okay. But even so, the case law that I'm finding, because I got it from you, that parallel court.
Parallel search.
Yeah, the parallel search, he can't even do that. Even once you voluntarily invoke federal jurisdiction, all the classic argument that you try to do is waived. You can't even do that. Now, if I would have brought it into the federal court, it would have been different. If I would have went straight and filed in the federal court, it'd have been different.
So I guess he's arguing that the federal court has supplemental jurisdiction over the state claims, even though they're. But this is one thing. When he's saying this action, he's referring to what you filed. You see that?
Correct. In the state court.
No, action is C 1331 is supplemental, so that's why it has C. Oh yeah, there it is right there. It has supplemental jurisdiction.
Yeah.
Okay, so that
So
is one which may be under this. There's a some kind of federal law question somewhere in there. And they did it within the time period. Okay.
yeah, I think he like on day 28, and that's what caused the other one actually to go into default because the attorney in the state cases, he thought he was gonna take both of them, but I filed one of them a few days early, so that passed the 30-day mark.
Where's your state claim?
In Fayette County, Georgia.
Okay, I don't know if I can even get that, but let me see something right here. This is becoming interesting. It's definitely taking me a little bit farther than I wanted to. Okay, so yeah.
So that's why I gave you the case. Now I want you to kind of, because what I did, I filed for a preliminary injunction, and he seemed to be entertaining it. I filed for a preliminary injunction and also pretty much let the case, be judged on his merits.
So here's your issue right here. Okay.
Yes, that's exactly. Yep. 1.2.
No. I see it right there. So in other words, your action, which a lot of guys could have it even in their state actions, is what we raised. There's a procedural error in so you never went to court? They never noticed you?
Nope.
That's intriguing.
Never noticed me, never gave me the opportunity to be heard, never gave me none of that stuff. None of it.
Those are fundamental errors, then that makes sense. See? Yeah, that seems to be pretty good.
When I was doing my research, that Iqbal and Wombly, that's the one that get most of the cases that get dismissed that I was studying. That's how they get dismissed. So I had to kind of like re-engineer my arguments to make sure they meet that Iqbal.
Yeah, the Twombly, Twickball, yeah, it's pretty rough.
Yeah, man, it's real rough. Y'all like, God, can't nobody get by.
Well, and I guess you told him also that the standard is the standard.
Yeah, exactly. Yep. And since another thing that I think helped me is because I moved to the federal court. Now I can just straight talk Title 4D Social Security Act. I ain't got to really focus on state specific laws. And that's what
you're gonna have to show where they're applicable to, which would make it pretty interesting to see.
That's what I wanted. I wanted to give you the case so y'all can pull up on your own and check it out. But I got a class up in the start at 1:45, so I need to get ready. But I just want to come in for a second. Like I be peeping you out, man, and you probably the most powerful one out there for real. So I appreciate what you're doing and sharing information. But you got the case now, so if the judge, I'm waiting for his response to the motion for class certification. So when he responds to that, I'm gonna light his ass up. But I got some more documentation. I'm gonna light his ass up, and then of course the judge gonna take it in and review everything. But if he grant that preliminary injunction, it's pretty much it's over with. And I don't see how he can ignore it. But I mean, he could ignore it. But just like you pointed out, I think he already made it man about number one, number two. I wonder what they mean by number three, this Rooker-Feldman abstention. They can't even do this now. So let me give them another chance to try to correct themselves. They didn't correct themselves. So I think he probably made his mind up on that. But now when I came back with the class certification.
Instead of worrying about that, just wait to see what he does. But I'm thinking that your issues are fundamental. So I can see those potentially making it through.
Mm-hmm.
Because of the lack of notice, I haven't looked at enough of. They haven't argued that they did notice you, that they proceeded without giving you an opportunity to be heard. That hasn't been argued either, correct?
So it's well, I know you've been doing it for way longer than me, and I was reading how if they don't address certain things, they pretty much conceding to it.
They're waiving.
Like
they didn't. As I said, they didn't argue that they did serve you. They didn't
correct
that you did get an opportunity to participate. They didn't argue that. They hadn't argued or put specifically an argument against what your allegations are, because don't forget, your allegations have to be construed or taken as true. Within the
Correct.
of it have to be taken as true.
So, and that's what I'm hoping the judge looking like, okay, he brought up all this stuff. Y'all ain't saying nothing about that. Y'all talking about procedure, but y'all the one brought the case to the federal court. So I'm gonna give y'all another chance to kind of, clean it up. He came back weak, like real weak. It's some young lawyer from I think he's from Italy somewhere, some young dude, he probably like 30 some years old, but I don't think he understand the magnitude and like if you one false step, man, you gonna be in a big he already in the world of trouble now for real, because the judge sent the order out saying, answer the man. Instead of just dismissing my whole case altogether, he actually engaged with it, which made me kind of excited. So I hope I ain't getting ahead of myself, but we'll see. Y'all can pay attention to it, man. I got to get ready for the class, and I'll be on the time y'all channel. I got you on a notification every time you come on.
All right, appreciate it. And the support
All
and
right, no problem.
in case.
All right.
That went a little bit longer. I see we had the usual haters pop in, but we'll be all right. We don't miss a beat here. Now, that being said, any other comments, thoughts, Dele, anything you have to say to what matters, not what doesn't matter?
What do you mean, like, as far when you say what matters doesn't matter?
No. So you have any thoughts or comments?
No, not on that. No.
Okay, no, it's something that doesn't matter, don't matter.
Yeah, no. I mean, other than that, I think what I said prior to, which is, we're at least with me taking over, going forward. Like I'm probably my thing is not to recreate the wheel, but I'm probably going to start out as, just holding meetings where we could kind of all come together and analyze our case if need be. We might not go into details, but high level stuff. And I'm guessing at some point when I get comfortable, start doing consultations and whatnot as well. So.
Oh, it's pretty interesting. I got a class action lawsuit against John and Jane Doe's 1 through 9 employees, agents of the FBI, on behalf of themselves against the Department of Justice. So I guess it's some new filing that just came my way as well.
Oh, wait, the class action came your way?
Well, somebody sent it to me to take a look at.
Oh, okay.
No. I ain't got nothing to do with that. That's well above my pay grade. But it's always imparting as I get ready. Well, actually, I think I have an evening available. I'm just now finding out. I thought.
And we do have I forgot to mention, we do have the Telegram group chat. Let me see if I could quickly get the link in here again. Shoot. Okay, hold on.
You putting it inside the chat?
Yeah. But it's on my computer and I was trying to get it. I'm on my tablet, so I'm trying to move it. 1 second. All right, it's in the group chat.
So download this guy Rose. His case is pretty interesting. Richard Rowe. Gotta give him credit. He's gone in. I don't think he's definitely not off with potentially with the fundamental issue. I don't know about the money issue, but the rest of it seems to be pretty tight. But go ahead, continue. Daily.
No, say no. It's gonna add the group chat where we can chat offline or whatnot if need be. As far as like the group, putting things that might have helped them, questions that you might need answers. Again, I'm not saying I'm the gatekeeper of all this. Like we can all share information and stuff like that. So.
Yeah, well, that's an interesting term too. I like to think that none of us are call ourselves gatekeepers or what have you. It's been said once or twice that sometimes it's like I'm keeping information from the hood, but at some point people have to take the onus for their life's endeavors upon themselves. It's not going to be up to everybody else to kind of save us. But the reality is, just like this gentleman here did, Mr. Rowe, and I appreciate him for stepping out here and joining the show with something that's substantial as far as information or substantive information that can help people grow. But he made it pretty straight and to the point, and I think he has something there. That being said, at the end of the day, everybody is going to have to go in there to seek their own relief. So, any thoughts or comments before I get out of here? Cool. Hey, it's always imparting. Sometimes it's not about right or wrong. More importantly, it's about clarity. You never reach resolution if you're not willing to engage in honest dialogue, even if the dialogue with yourself. Take time to hug the person you love the person you hug. On behalf of GD9 Attorney Pro Se Consultants, I'm Greg Doss. I'm DJ Squid. I'm saying peace. I'm saying chicken grease. I'm out.